this report for Parliament so we can get the legislation going. All right? So, do you have any objection? The ratification of the meetings of June 26th and July 9th. Okay? Can I take the minutes were read and we confirm the minutes? I think that 12 sittings.
Those are 12.
Yeah.
14.
14. We have all the minutes. Can I take them as having read and we move for the confirmation? Moved by Member Golding, seconded by Senator Karen Morris. Right. What I'd like to do is take a look at the report. That it was sent to us a little bit late, but have anybody a chance to go look at it? The preliminaries outline is clear what we're here to do and the challenges faced. Now we need to decide how we move forward on this in terms of the proposed changes. And the comments, Senator or member? Section by section, even if we have to come back over them. Section 1, short title, there are no proposed changes. Section 2, the interpretation. Now these are the summary of the report and decisions we made, and now we must confirm or change. Because once we confirm, they will now be go through cabinet. No, they'll come back to Parliament.
Yes.
And then.
After you agree, then we sign it and it comes to Parliament and table.
Yeah, and they become changes with the assistance of
Chairman,
Ms.
you're on page 6 of the report? You're on page 6? Right, in the definition of law enforcement.
Has to do with identifying signs and symbols. The committee accepted recommendation that should be placed in the subsection 6.3 of the Act. I don't need any dispute there. Criminal organization.
Yeah?
Yeah?
Before we get into the recommendations, I had one comment on the introduction, which is that the committee has been sitting since, I think, November last year, based on the minutes. And in the course of that time, what we have seen is, in the media anyway, increasing reliance on the legislation. So we hear reports quite frequently now of persons or groups of individuals being charged under the anti-gang legislation. So in a sense, it is being more and more mainstreamed into the strategy of the security forces. And we have had one major trial which is not yet complete.
I think it's for the judge's decision. They are waiting the ruling. I think all the hearings have been gone through, and the judge, in fact, looking at his ruling should have come this week, but he's off the island, I think.
So I think that the introduction ought to make those points, because I think the whole review that we've done needs to take into account what has happened over the past 10 months in that regard, you know.
Okay, I certainly agree with that, but part of it is that I think one of the suggestions coming out of here, which is not directly legislative, is that when we pass legislation, we need to get the primary stakeholder at the right term, the police force, DPP, and others involved, because I think what is happening, the police is just getting more familiar and improving their investigative capacity in the area. In this,
I can assure you that the police the police and the DPP's
DPP.
office were very involved
Yes.
in the development of that legislation. In fact, the Commissioner of Police attended legislation committee himself and had an input and was quite helpful in relation to particular clauses based on his experience. So, I mean, what has happened is that I think it's taken a while for the force as a whole to get used to it and learn it, and the DPP's office. But we're seeing it more and more now becoming an essential tool in their arsenal against gangs. Yeah.
They have well over 120 members, alleged gang members, but they're not finished yet, across the island, east to west, and some pretty significant members of the leadership of various gangs, and it's having some impact in the areas that they are operating in. So
I only raise that because I think the background of the report is a little dated and ought to have a paragraph as to, you know, basically saying what we just discussed.
Concluding paragraph, or near the conclusion, that the primary legislation will be used much more extensively and it's become a primary plank in the anti-gang activity, right? And there's, you know, given the information, there are several more coming up. There are 14 major cases now. Yep, thank you, Member. Comrade said, Section 2 interpretation, definition of criminal organization.
So, Chair.
Sorry, rather than that being the introduction, it could probably be in the issues and analysis section, Section 3, rather, yeah. Which is on pages 4 to 5. Yeah, all right. Hi, Don. Okay.
No, man. We were all a little bit late today, but I think we are now going through the report, so hopefully we can, if we don't settle it today, should we would have one more hearing to get this out of the way, right? We'll get it active. One correct all of it, but the number of gangs listed is a little bit different from the current listing. Is yours mentioning under law enforcement?
No, actually, on the definition of criminal organization, just a correction. Your committee noted the proposal from the Ministry of National Security for the definition of court to be amended.
That's page?
Same page 6, right at the beginning. It shouldn't say criminal organization, it's really court. So that heading would have to change. It's in the definition of court that there is a reference to the RM court.
Oh.
So it's a typo, but it also needs to have a different heading. Because at the end of the day, the committee decided not to accept the recommendation because the act that renamed the courts has already taken care of all the name changes.
Yes,
but the point is,
RM
it should say from
court.
the definition of court to be amended to replace RM court. It's not criminal organization.
So the heading of that first point under Section 2 would be definition of court. And then the first line would read, your committee noted the proposal from the Ministry of National Security that for the definition of court, in quotes, not criminal organization there.
And
go on to the definition of criminal organization.
yes, then you would have to know in the second
Should have a separate
heading, definition of
Yeah.
criminal organization.
Yeah.
And then I wanted to make a comment there. So I know there was discussion about the definition to include identifying signs and symbols, but I think there needs to be a little more clarity about, well, actually, it goes on to say your committee accepted the recommendation and agreed that it should be placed in subsection 6.3, but I think it should say your committee did not accept the recommendation, but instead agreed that identifying signs and symbols should be placed in section 6.3 of the Act, because the committee didn't agree to amend the definition of criminal organization. The committee agreed to amend section 6.3 to deal with signs and symbols. So I think that should be adjusted.
That paragraph should have its own heading, definition of so why I would say signs and symbols, right? Yeah, because it's actually not the definition of criminal organization that we're troubling. It is the section 6.3. But anyway, it needs a little heading because it's not part of the previous one.
But I don't think it's definition of signs and symbols.
No. I was going to say just signs and symbols. Yeah.
Needs to be changed around, and if you put the last paragraph before your committee noted the proposal, and you could give it, because remember that the last paragraph, it deals with the definition.
Yeah, and I don't remember this. I don't remember. I say I don't agree with the final paragraph.
Before you move on,
I don't think that's what
Member Golding, before you move on, there's the heading for paragraph 2 of your committee, they accept identifying signs and symbols.
The following paragraph, the third paragraph in that
Yeah,
section.
but the second paragraph, what the heading should be for? What's it?
You're saying that.
It could just be signs and symbols.
But they had proposed that it
or 6.3. I don't know. That's not a big issue.
Just to clarify, I think the reason committee clerk is making a point is because this came up under the discussion of the definition of criminal organization. So I think that is why it was placed here. But it could actually even just simply go under 6.3 to say that even though it was discussed and then we deal with it in 6.3. So it could be moved and just be completely addressed in 6.3.
Okay.
On the third paragraph, the definition of criminal organization is central to the legislation and is no doubt central to the cases that are before the court. I am very reluctant to recommend an amendment to it, especially when I read this, which I don't think accurately reflects what that definition currently says, because it already talks about the association of 3 or more persons and says whether the language, I don't have it before me, but the language isn't limited to whether there's a gang or an alliance or anything. It's deliberately general enough to cover any association, whatever you might call it, as long as it's 3 or more persons, and for the purposes of committing serious criminal activity, serious criminal offences. So to go and tweak it now, when there is this pending litigation, I personally think is unwise.
You should not.
I don't think we should trouble it. I mean, if the case is, if a case decides that there's a problem with it, then I think that the legislature needs to quickly act to solve that. But I don't think we should preempt.
Yeah, because the current legislation speaks up with 3 or more persons already for committing.
Sorry, Chairman, I think that it might have been an error because the summary sheet actually says did not accept the recommendation for the change in the definition of criminal organization. And I look back at all my notes, and I also recall a discussion in the DPP did say that she does not have a challenge with the definition of criminal organization.
All right. Yeah. Law enforcement.
Chairman, I'm seeking clarity. Is this supposed to be a reference? It talks about the the bill entitled Constabulary Special Act. But was this supposed to be referring to the bill that's going to repeal and replace the Constabulary Force Act? No?
They're both relevant. Remember, there's the special, what is that called, Constabulary for Special Act?
Chair, if I may, I think it was a reference to the proposed legislation to effect the merger between the JCF and the Island Special Constabulary Force.
We just remove the title of it and just say with the expectation that legislation would be, will soon address this matter.
Yeah. But has that been done?
Since you don't even know what it's called. The water tastes weird. Taste of water.
After I see your face.
No, I may be funny. Tell me if it tastes normal to you. Tastes alright?
How do you amend this to reflect the thinking?
Well, a decision would have to be made as to how that piece of legislation will be dealt with, having regard to other pieces of legislation currently being proposed in respect of the constabulary force. It might be tidier to do everything in one package, even though this bill had already been far advanced. Yeah.
So what, we would leave it as is for now in the act that we have and wait for that piece of legislation to fix it at the appropriate time?
No, I think that one could proceed with deleting it because administratively the merger had already been effected.
Would we be removing?
Deleting the reference in paragraph B to a member of the Island Special Constabulary Force.
Because this says nothing about that. This paragraph says
Right.
zero about that.
No, I think that's...
So we need to redraft this paragraph completely. This is reference to the Island Special Constabulary Force. Yeah.
Perhaps then, in that case, rather than referring to the expectation that the bill entitled the Constabulary Force would be addressed, we could just refer to the fact that the merger had, due to the fact that the merger between the two have already been effected.
Clarified definition of benefit. No changes. Page 7, definition of recruit. Now this last item, I recall, how is this again?
What's this?
We're removing reference to the Island Special Constabulary Force Act again.
Sure, that's what we had just discussed, so I think it's
Right.
just a duplication of what.
All right? Yeah. There was no proposal for Section 3, Section 4, offense of recruitment of a child to criminal organization.
The second paragraph is a little confused.
Yes, section 4.
Because 4.1 is dealing, I don't have my bill, my act unfortunately, but 4.1 seems to be dealing with saying that a person shall not recruit a child to be part of or participate in a criminal organization. And the MOCA provision, I don't think was...
I think the MOCA provision was to, in fact, if there's an aggravating...
If some atrocity is part of, of the initiation or recruiting process,
it considered more
should be
serious.
an aggravating factor in sentencing. I think that's the point they made.
Yeah.
But the words in bold at the end.
Well, if we may be allowed, sorry, in terms of at least a suggested rewording of the first paragraph, which would help to clarify, Mrs. Mesado had looked at the matrix, the original matrix, and the comments that were made. So.
Okay, thank you. What I had seen on the matrix was basically that the act of persuasion alone in recruiting a child to be a part of a criminal organization should not be sufficient to warrant a criminal offense. As the
that is a proposal from Norman Manley Law School.
Right, I was on.
But we didn't accept it.
No.
No. Right, that's understood. But the second paragraph with MOCA.
Just to clarify, I was just suggesting that we could add that, but I'll give Ms. McCarthy.
Yeah. What the suggestion in my MOCA that we add this as an additional, if there's an aggravating circumstance or aggressive activity, you would in fact become more serious, or should be considered in the...
My problem is the final sentence in that paragraph where it says, your committee decided to accept the recommendation that recruitment of children would be another aggravating factor.
Yeah, that's not correct.
But that is the essence of the offense to begin with. Yeah, so that's not what that was dealing with.
No, the final sentence
I think it was the rites of passage that where they have to commit the atrocity.
It would be a more serious...
That was the aggravating factor, not the way it was expressed here.
It needs to be reworded, rewritten.
Be worded to basically to say that your committee decided to accept the recommendation that if acts of violence or intimidation or something like that in the course of recruiting persons ought to be an aggravating factor in sentencing. Yeah.
It's not the recruitment, you see,
if you're forcing the child or you're forcing them to a rite of passage, sentencing that individual,
I think
that should be taken into account in sentencing the individual who do it. In other words, recruitment goes from just convincing the child to take a firearm to school. Fine, you send, they'll be charged and sent to that base, but another one may take the firearm and give him to kill somebody. And that should be better. I think we understand, just getting the wording right. Getting it right.
Is it right that the nub of their point was that in the process of recruiting a child, there were acts of violence or intimidation committed that ought to be an aggravated feature in sentencing somebody for committing the offense under 4.1, the recruiting offense? Is that the point?
No, I just have an additional question, and forgive me because this was sent late last night and I haven't been able to conclude my review, but does the report explain what we mean by what the committee means by an aggravating factor? So I mean, I know it's a term understood by bright minds, but what does it mean? Does it mean 5 years on the sentence, or usually it means something additional to the penalty that you would have normally received? So I don't know if there's clarity anywhere else in the report, but I noticed that this aggravating factor is a theme throughout, but I think there needs to be a further explanation on what you mean.
I mean, there's a model in the lotto scam legislation where there are certain factors that are treated as aggravating factors in sentencing. We could look at that and see if we want to follow that. I think there's also something similar in the human trafficking legislation.
Well, if I may, just a reminder that all of that took place in the context of considering the provision that was already in this second schedule, which in relation to recruitment of a child to a criminal organization of the well, I don't know if it's the same page. No, it doesn't have a, but it's right, where the penalty would move from a term not exceeding 20 years to, an additional term not exceeding 10 years. So that was the aggravating, that was the enhanced penalty where there was that aggravating, right. So I think it was just a matter of expanding that to cover these other scenarios.
So the mechanism for dealing with aggravating factors is already in the Act with an additional 10 years, but it's just adding this as one of the different aggravating factors that can trigger that. Yeah. Yeah. Yes. Yeah.
All right. Section 4.2, a person contravenes Section 4.1, commits an offense. There are no proposals for subsection 2. All right. Section 5. Section 5 for the recruitment of adults should also carry some aggravating factors. How did this relate here now? Yeah.
This seems to have two different elements. One is that the provision of, in 5.1, that the act, for this activity to take place within the vicinity of a school ought to be an aggravating factor where an adult is involved, as it is in the case of children.
You want to look at the legislation, the schedule?
Okay.
That might be helpful.
Yeah, it might. Thank you.
See it here.
Yeah, adult here, see.
So
currently, there's no aggravating feature or factor in the sentencing for recruiting an adult to join a gang. And I think Mocha's point was where the recruiting is done within the vicinity of a school, that ought to be an aggravating feature or factor in sentencing in the same way that it is in the case of children.
So
5.1, yes, that's. Is just another aggravating factor added to Section 6.
So do you agree to the wording, sir?
Section 5.1 is really another aggravating factor being added.
Chairman, some of us are having some second thoughts about this particular one. And I was wondering if we could remind ourselves as to the justification put forward by Mocha for this proposal. My recollection was that it was because of the impressionable minds in a school, and to have recruiting activity around the school can influence the children and how they think and their amenability perhaps themselves to be recruited into a gang activity, and therefore in order to send a strong signal to gangs not to attempt to recruit children or adults within the vicinity of the school. There's this aggravating element to the sentencing where they do that. But there is some of us are feeling that isn't really relevant.
Not relevant.
I don't recall whether there was an overwhelming preponderance of evidence that would suggest this is a problem. And in any event, one does have, as KD said, a judge does have the ability in sentencing to take into account all aspects of the evidence. I just think that legislation still has to be rooted in a kind of pragmatism, and I'm sensing that this is going a little bit too far. If one reminds me of what motivated Mocha to say this, and it is persuasive, then I will reconsider my reluctance to have this as part of the legislation. But right now, I don't see the point.
So it's not, you already defined recruiting
Yes.
a child as a crime, right? For a criminal organization, and the judge will have the discretion of sentencing him, take into consideration all circumstances.
With the child, it does specify in the schedule that where the offense is committed within a certain proximity to the school or to the educational imprisonment. My reluctance is to attach it to having where an adult is recruited under those circumstances. And I think, in fact, it strengthens the legislation when you single out the circumstances of the child.
Right.
As being, this aggravating aspect of it, rather than to also, to me, it diminishes it when you say it's also if you do an adult. That's just my thought. That the focus here, as it presently is on the recruitment of the child, which makes it, a heinous situation.
So in fact, adding this as aggravating factor would not necessarily, for adults, would not necessarily be, is not relevant.
When Mocha was raised this point, I said that I didn't think where the recruiting takes place is really relevant in the case of an adult, whether it's beside a hospital or at the stadium or by a school. There's no real reason there to have an aggravating provision. Their response was, the rationale for it is because of the impressionable minds in a school, and if there's a culture of recruitment of gangs, adults around the school, it can impact how the youngsters in the school
That was part of the discussion.
Process all that.
And your discussion as to?
Sorry, Chairman, I was just going to remind members of something, comments made from Mr. Park of Mocha on page 7 of the November 27 minutes. So no evidence was really provided or data, but he said, he noted that gangsters also use children to move weapons and ammunition, to act as lookouts, and oftentimes they were used as shooters or participants in feuds. He said that resulted in the development of a situation where children were not viewed as non-combatants, but rival factions. But they are viewed as combatants, which explained the killing of children in certain communities where the incidents were attributed to gang violence, and then went on to ask for the aggravating. So I think just indicating that the adults are using the children in a certain way, and that was part of the rationale, I think, a part of the rationale of the proposal.
Well, I think after a protracted discussion, there was a decision was made to link it to not just the fact that the recruitment took place in front of a school, but that there was some act of violence committed at the time. So that is what would, I think, kind of limit or distinguish it.
Yes,
But that didn't make it to the report.
right. That's my recollection of it. The concern was criminal activity or gang activity taking place within the precincts of a school. That was the
But
concept.
I think that's why the portion in bold refers to committing an act of violence in the vicinity of the school.
How do we let it?
You know, Chairman,
Let's hear what they...
I get a little concerned when the executive gets too intrusive in relation to sentencing. And when the executive begins to think that judges are so isolated that they are not cognizant of issues which ought to be taken into consideration in imposing a sentence. This is a high court judge. The executive. Well,
Chairman,
and the legislature, but it comes from the executive to the legislature. So that's why I started with the executive, because that's where the policy begins. And then...
Senator, I take your first principle very, very, very forcefully, that the executive should not intervene too much in the detail of sentencing. Of course, the second comment, I think, sometimes forces the executive to look in that direction. Some of your judges behave like they're not here. But I would make that be the principle that governs setting the legislation.
You would like?
I would not use that as the principle on which to develop the legislation. I do agree with you that we should not be too intrusive. I'm just saying that things some of the judges behave like they're not quite here for true.
Well, you know, because...
But I would not use that as a basis.
I understand, but just a short comment on that. Because sometimes some of the reporters behave as if they weren't in court.
That too. What's the suggestion that we should leave 5-1 undisturbed?
Yeah.
That's a consensus?
So
We take note this way, we're not going with this 5-1. Amendment to 5-1. No amendment to 5-1. 6, offense of being a part of participating in. You're going to leave 5-1 undisturbed. Yeah. Accept. Yes. Accept.
You can't really delete it. What you'll have to say is that the proposal from Oka was not accepted.
Yes. We'll encourage the Senate to take us a place on the High Court too. Six and 6-1 were not amended, right? No proposal for amendment. 6-2. This will refer to in section. Do that in section 2.
Yes, sir. 6.3.
Definition of force. The amendment to section 3 was in fact indicated before.
Yes, sir.
Yeah.
But then just make sure that I agree with what is. It's three different things.
Look at legislation. All right, we had accepted the proposal of 6.3 that the signs and symbols be added as section H. Six four. Good. Section 7.
The proposal is to remove the conjunction and before the final paragraph in the list of what factors may be taken into account. Yeah. In both 7.3 and 7.2.
Yes.
Is that right? No. 6.3 and 7.3. Yeah. All right. Yeah.
Section 7. Seven 3B, committee accepted to amend the language, remove the word and the word organized. Yeah, right. 7 remains substantially the same. Section 8. No change. 10, offense of aiding and abetting.
Excuse me, Chairman. Just a little typo here. In relation to section 7.3b, in the first line, your committee noted the proposal to remain consistent with the amendment at, it should be section 6.3, not 7.3.
Okay. Okay, thank you. 10.
One thing though, in 6.3 we were replacing and with or. No? Oh, but agree, all right. Agree to remove the word and. All right. So this thing in 10, I don't really understand that paragraph where it says your committee noted the proposal from the office of the DPP for additional offences in relation to persons who counsel, give instructions or guidance, finance, or otherwise provide support to GAM members, as well as to afford law enforcement personnel to search and seize documents they may have in their possessions.
That's because we were voting and there was no decision.
I mean, one of the provisions that was in the DPP's recommendations were that there should be a power of search in this act, and that was, yeah. Yes, I just, this way that sentence is constructed was a little confusing to me, where it went on to say, as well as to afford law enforcement personnel to search, like a word is missing or something.
Have it placed in the,
So it was not accepted.
it was not accepted here.
I just put it in
Afford them to
the-
search?
So, if not accepted, it should go in the JSC Act, but 10.1 was accepted, or the entire proposal was, okay.
It's to search, is it? Or the power to search?
The
I'm
entire
just
thing
saying
was,
some words, it just...
what's I mean? It's not it was not accepted.
No, I know, I realize, but
Right.
it's just a bit...
Yeah, need to be written, even moving on to.
Okay. It's the same thing for 10. I wasn't sure. So they didn't really explain this. When the DPP came, they didn't really explain this part. That's why I left it like that, because the committee
Blue.
didn't go back to the
Okay.
cipher.
In 10.3, it says your committee decided to accept the recommendation that for subsection 10.3, if the person incites or induces a child and it occurred within, then it would be an aggravated offense. Some words missing there as well, I think.
300 meters of us.
I think it was to the,
Yes, within 3 hours, just left out those parts. Within 300 meters of his school, so. Within 300 meters of a school. Within 300 meters of a school.
Yeah, it's there.
I just wanted to question whether the "and" there, though, should have been an "or," so it would have become an aggravation where the person was a child or it occurred within 300 meters of a school.
I think if it to be consistent with the rejection of the amendment that had been proposed before for adults, I think it would have to be "and." In other words, the fact that it occurred within the vicinity of a school was not accepted as an aggravating feature where the recruitment was of an adult. And in this instance,
Then, but in that case, if the child is recruited, but it's not, if the child, well, the aiding or abetting there, all right, it's.
I think if the person incited or induced was a child, that ought to be an aggravating factor, whether it occurred, wherever it occurred. You know, I don't think it should be conjoined with a particular location in order to become an aggravating factor. I would suggest the words "and it occurred within" should be just removed. This is on page 11, in the square bracketed sentence, just below half line, so to speak. I'm suggesting that the words "and it occurred within" should be removed, because we've already rejected that as an aggravating feature in relation to adults. If you accept the principle that if the person induced or incited was a child, that should be an aggravated feature. It doesn't really matter where that takes place.
means with the amendments proposed.
Why would we have the sentence which follows, which is shaded, why would we have that in our report? Your committee agreed to await the appearance of the ODP.
It was just a reminder.
No, you take out this now. You take out the not because they. Which one you take out this one?
Yes, sir.
Chair, in any event, all of these provisions here, what we have in 10.3, 10.4, it's really all a duplication because it's really covered up by the reference to 10.6 on page 12. So I think we could have deleted the highlighted portions and keep just the part referring to 10.6.
All the way to 10.6.
Because it has a 1, 2, 3, 4.
Simplify the report, let's do it. Yeah.
But then it still has within the school, within 300 meters of the school. Take what within the school?
When we say, when it says for the aggravating factor, section 4 should be extended, what is the aggravating factor, section 4 that we're talking about?
Well, based on the discussion before, then the provision with the paragraph here could then be amended just to refer to where the person incited or induced was a child.
Yeah, just rather than refer to another section, yes, of a person who is at yes. So how would that be worded? Your committee noted the proposal of MOCA that the aggravating factor be extended to subsection 10.6 for the incitement and inducement of a person who is a child to commit. We rejected the act of violence in the precincts of a school, right? We rejected that as an aggravating feature.
My suggestion would be in that paragraph on page 12, section 10.6. The words in the third line, at the last word in the third line, you could delete from there, person to commit a serious offense or act of violence within 300 meters of a school, and just replace it with the word child. So it would read, be extended to subsection 10.6 for the incitement or inducement of a child. Full stop.
So section 4 be extended to that should be made.
Section 12. Square brackets have the same thing over here. This one. Section 12.
This paragraph about 11.1, I don't know what it's saying.
You're going to 11.1 refers to expanding the concept of benefits, really.
Chair, my recollection of the decision was that what is currently there as 11.1 would now just form paragraph A, and that a new paragraph B would be added to provide for an offense for a person who, in order to gain an unlawful benefit, professes to be acting on behalf of or on the instruction of a criminal organization.
So it becomes part of 11.1 rather than okay.
An A, the decision was for an A and a B because the first few words would form the chapeau. A person shall not, in order to gain an unlawful benefit, profess to be, and then you divide that into A, and B would be acting on behalf of or on the instruction of a criminal organization.
Can you word the paragraph for the report to make that clear, because it's not clear from what's there now.
Okay. Reword that one. You go to section 12. Section 12.1 is also a little bit. Where is this in blue? Sorry. Pass with the gang. So
12.1 was saying that if the action to prevent someone from ceasing to be part of a gang or took place within the vicinity of a school, that would be an aggravating factor. That's what I believe this is trying to say. But given that the trend in this meeting has been to eliminate that aggravating factor of being within the vicinity of schools, save and except in relation to recruiting a child into a gang, then I don't think, if we're following that line of reasoning, there's any place for this. Unless it involves children, perhaps.
Essentially, that if you try to prevent someone leaving the gang, you're going to charge him for that. But that's covered in.
Moko was saying that if you are trying to dissuade someone from leaving a gang, maybe using violence or whatever, and if you did it within the vicinity of a school, that would be an aggravating factor in sentencing. And the committee in the meeting, had accepted that point, I think. Hence it got its way into this report. However, in this meeting, there has been a reversal of that position.
Right.
So that the only instance that I can think of so far in which we've accepted that an activity within the vicinity of a school should be an aggravating factor in sentencing is where that activity is a recruitment of a child. Mm-hmm. And this is not dealing with the recruitment of children in 12.1. This is dealing with preventing or dissuading people from leaving a gang. So, yeah. It's a pity Mo can't hear, because they obviously felt strongly about this issue, because it found its way into several provisions.
If you're going back to if we have removed this section, then this would be kind of little relevance.
Well, insofar though as the dissuading if the person that is being prevented from leaving the gang is a child, would that be the flip side of the recruiting? So maybe there should be a provision, right?
Okay. So we retain the first section and delete it. the end of it?
No, I think this needs to be recast.
Okay.
So that the aggravating factors where the 12-1 activity is in respect of a child.
Okay.
Yeah.
Undisturbed. The offense of taking retaliatory action.
This is where the state is putting up people who are giving information who are not witness.
As I understand it, the JCF wanted to insert a provision in the law for placing persons into the care of the state with their consent, where they were a target of a gang, adverse action from a gang. And I think the decision was that can be done administratively. You don't need to put that into the legislation, and it could even create some liability, because if there's a provision that says that the state is supposed to look after targets and put them into state care, if that didn't happen, maybe somebody was injured or their family would have a cause of action against the state for that, and that might not be a responsibility that the state is in a position to take on.
This in relation to 13.1 you're referring to now?
Yeah, yeah. So I think,
well,
I was just kind of explaining.
It was not accepted. Right, so 13.2, so we go there. 14, offense of impersonating law
But like in
enforcement.
14.1, we just set out the provision and there's no comment on it. So why set it out then?
Is this in law already? Offense of the impersonating law enforcement officer.
Yeah, we set out section 14.1, but there's no comment on it.
Okay.
So I'm not sure why we set it out.
But this is...
There were no proposals, sorry.
Yeah. 14.2, a person commits an offense, but that's established in law.
There are no proposals for 14. Sorry.
14.1 and 14.2 go together, and the comment is really that which follows 14.2 here is really a comment about 14.1. I kind of understand why they did it that.
Okay, 14.2 was adding some aggravating factors that are not necessarily there yet. Cover, dress, high caliber ammunition. Any problem with that?
You know, this would have been better if the chambers and CPC and legal reform had a chance to edit the report before it came to us. Huh?
No, but it would save.
Yeah.
But
yeah,
we are spending time to do is trying to rationalize some of the recommendations
we had already decided that we would have helped behind the scenes with some typos and all of that as well. And in any case, it would have to come back to the committee for you to review. So, I mean, we will assist. But just in terms of 14, because 14.2, doesn't seem as if a recommendation is really there. And in fact, I don't think the committee really took a decision on the approach. I had made a suggestion, I have it in my notes, what's in the blue, to an extent, just saying that what we could have done was amend the constabulary force to deal with this issue so that it would be addressed in a more general way and not just specific to gangs. And I think what is missing is the decision of the committee in relation to 14.2 or 14.
Well, for example, it says, rather than using law enforcement officer for that purpose. I don't know what, that doesn't follow from what came before. It's kind of hard to understand what that's all about. But what about this using high caliber ammunition? How are we going to capture that? We don't really have a definition of high caliber ammunition, but I assume it's what is used in an assault rifle. Yeah. Would the suggestion be, for example, a general provision somewhere that the use of a high caliber, a weapon which fires high caliber ammunition, which would have to be defined what that is, in the commission of any offense is an aggravating factor? That would make sense to me.
Agreed. That is something that the committee could consider. But what was before the committee was slightly different when I'm looking back at the proposal. And I'll read what's in the Constabulary Force Act now. If any person shall have in his possession any arms, ammunition, clothing, accoutrement, or other appointments furnished for the use of the force, and shall not satisfactorily account for his possession thereof, or if any person shall put on or assume the dress, name, designation, or description of, and assume to act as, or to personate a constable of the force, every person so offending commits an offense. So it was relating to matters that were really only for the force. So there are weapons that are really only designated for the force, I assume. It would relate to that. The suggestion now is a different suggestion. So that is something the committee could then have to discuss.
I can see why Mocha would say that in the context of organized crime, to use police paraphernalia, military paraphernalia, in the course of organized crime ought to be an aggravating offense for organized crime. I can see that. I mean, separate apart from the general offense that exists there, for anybody to use police get-up, which is an offense in and of itself under the Constabulary Force Act. I can see the concern about these criminal operatives using, the get-up of the state law enforcement machinery in the course of their activities, and how nefarious that can be and confusing to the public, and they can, people may think that they're dealing with law enforcement when they're dealing with, serious organized criminals.
Weapons and that would be added to this.
The high caliber weapons thing is they had recommended that
Yeah.
it be added to this.
Yeah.
So that if criminal gangs are using
Yes.
weapons that fire high caliber ammunition, that's an aggravated feature for, yeah.
Emerging, for example, the use of these drum magazines, which is a
Yes, though the point was made, even if you're not in, if the use of high caliber weapons
Yeah.
commit any offense
right.
ought
Is
to
that
be
an
something
aggravating
that-
factor?
Yeah,
That's
Yeah.
my thoughts.
Yeah.
That you should restrict it to this.
I don't know if whatever is being deemed to be a high caliber weapon, can these be lawfully obtained and used by ordinary members of the public? So then it's just illegal, it's already illegal anyway. But I had a separate point though. So if the committee wants to include this in
response to that point, so you wouldn't have a license, presumably, an FLA issued license, so it would be an illegal weapon, but it wouldn't have any particular aggravating feature for the fact that it was a high caliber weapon. The law wouldn't recognize it as
So
such.
I don't know though then if we have to use this term high caliber, it would be then any but it would be any illegal arms, ammunition, anything that can't be acquired
I know,
legally.
But the point I'm making is in Jamaica today, there's a big difference between a man having a rifle, an assault rifle, as opposed to having a matic, a pi or a revolver. It's a different.
Yeah,
The
I think
level
what
of
the challenge-
intimidation and
yeah.
destruction is very different. Yeah.
No,
Yeah.
that's it. To define it, I think what's important is to define the aggravating factor to be defined, because you have to separate the weapons. Although it's an illegal weapon, a gangster with a 38 is quite different from one with a AR-15 and a drum magazine. I think you're trying to define that certain weapons need to draw greater ire from without telling the judge what to do. Should be considered an aggravating factor. It also suggests that the individuals who have it are part of an organized structure rather than just somebody who is. It's more likely a gangster will have an AR-15.
But if a person uses an AR-15 to commit a murder, or wounding with intent or some serious offense, rape, that should be an aggravating factor, whether or not you can prove that they were a part of a gang.
Yeah, there should be a general thing, but I agree say in the concept of a gang as well, it has some value because usually those who possess such weapons are part of gangs.
But remember, you always have to prove. If you're charging them under the anti-gang legislation, to convict them you have to prove that they were part of a criminal organization. So if you hold somebody with an AR-15 having committed an act of violence, it would be, I think the sentencing ought to be able to take that into account as an aggravating factor. That it's not it is a weapon almost of not mass destruction but serious destruction that has been used without having to prove that it was part of a gang in order to be able to take advantage of the aggravating factor. That's what I'm saying.
Yes, Chair. Well, Member Golding just made the point that I was seeking to address.
So where would you deal with that then if you wanted to make the use of high caliber weapons, which would have to be defined, say, in the course of acts of serious offenses, that being an aggravating factor in sentencing, where would it be in the criminal that's a draft. Yeah, okay.
It's where they're being made an aggravating factor in sentencing. But should that come on the Firearm Act, so whoever use it? Yeah. Mr. B, you just did the Firearm Act. I said the Firearm Act has just been, the drafting was just,
The technical team could consider that and come back to us.
We'll
with
be
it.
guided by a learned Chief Parliamentary Counsel. Minister.
Yes. Where should it be put? That this should be placed somewhere it is general, applied
I think there are
generally.
two issues. One is that the use of accoutrements of the security
Yes,
forces.
that's fine. That should be in here.
That should be an aggravating feature
Yeah,
in the
in
gang
gang.
offenses.
Yes, that's
And
clear.
the use of high caliber
That stays
weapons.
here.
Right, that stays in here. The use of high caliber weapons to collect.
Should be a general
should be a
aggravating
general-
factor.
Yeah, for any serious offense.
Right.
Yeah.
It's 15.1.
This is essentially, the idea here is to include an offense similar to what is in the lot of scamming legislation. That it's an offense to allow your premises
It's
to be
used
used
for criminal activity.
for further gang-related criminal
Yeah.
activity. Yeah.
That's fine. There are no proposals on 16, 15.2, 16, and 17, 17.1.
Chair, for 15.2, although it says that there were no proposals, having regard to the recommendations that were previously made about adding certain additional aggravating factors, I'm inviting the committee to make a recommendation that subsection 2 be expanded to include a reference to those additional aggravating factors.
Aggravating, especially related to schools, okay? Note. The section, the reference will make about schools.
There will be an expansion of 15.
15.2.
So 15 would now cover all of the circumstances that we've agreed should be aggravating.
Yeah.
So it would become quite a lot bigger. Okay.
I just wanted them to read it over just in case they don't record. Sometimes sometimes the recording does not work.
Okay.
I just wanted her to know.
Ms. Granspeet has soft voice. All right.
Are we on page 15 now? Yeah. Yeah. I mean, I don't want to jump the gun, but I have a comment on the fourth paragraph, 17.2.
17.1 was not accepted.
In the issue, we say here that we recommended, this is to do with witness anonymity, and the ministry had proposed the use of pseudonyms. I don't think it's uncover, I think it must be some undercover names that protect identities of persons, including witnesses in court proceedings. And we said here, you know, let's not deal with it here, let's do it in a separate piece of legislation. Now, I think we all know that it's not going to happen for a long time if we do that. So I would be inclined to consider putting a provision here that allows the court to order that the names of witnesses be, whatever the verb is from anonymity. I don't want to attempt to pronounce it because I'm going to get it wrong. But that verb, that there, in other words, I think we should deal with it, especially if you have a lot of those cases coming before the courts now. There ought to be provision for witness anonymity orders to be made. Yeah, I wouldn't wait until some new legislation on that is developed, because that's, you know how long that takes. You have to go start from scratch to do that.
I want to add my support to that recommendation, Minister.
That one legal draft so that primary legislation takes 2 years. I'm not a lawyer. Maybe we push hard, we get a little later, but it takes.
Just for clarification, though, I thought that this issue was covered in a way in 17.2 of the Act, 17.2A. So I'm wondering what additionally was contemplated.
I guess it doesn't kind of give any guidance to the court as to what form of protection it might take or anything. And I think in the absence of any guidance, you're asking the judges to really be bold and creative. And I think maybe there ought to be some provision that expands and says in relation to 17.2A, the court may da-da-da-da-da, which would be taken from witness anonymity legislation, saying...
Can you remind us of how it was framed? Because my thinking was that they could choose a designation, whether, you know, not that the court would choose a designation or so, but they could choose to be identified by in a particular way. Witness, you know, something. But do remind me how it was, how the recommendation was mooted.
Presently, Chairman, 17.2A says that in the interest of the administration of justice, public safety, public order, or public morality, the court hearing a case under this Act may direct that the identity of any person, including a witness in the case, shall be protected in the manner specified by the court. All right? So it's a general power to do that, but there's nothing here that gives the court any guidance as to how that might be done. And I was just thinking it might be helpful if there was something to say that the order under that section could include an order that the witness be referred to by a pseudonym or something along.
No,
yeah. There must be some model for this.
Anonymity of the witness be protected by the court order. I think you should include something there. Yeah. You're really just creating a stronger framework. Any comments here?
She's trying to find how they recommended it. And it might be important for us just to...
Chair, I think our recollection is that as part of the discussion that took place in relation to that, I think part of the argument was that there should be some indication in the section that these applications are to be made, should be made prior to trial, or can be made prior to trial. And so there's some comment about trying to put it into the marginal notes also.
I'm sorry, but why aren't we leaving this to court rules? Because this is how, because I remember having a discussion with Mr. Park at one point from MOCA and asking why haven't they made applications to the court? Because that's what you do. There's a judge, you can make an application. I think they haven't done that. I am a little wary of putting in guidance, because sometimes it can be seen as limitations or restrictions. This is also not a new provision. I'm trying to find another law that we have this in here. So I don't see what would restrict anybody from approaching the court, making an application and asking in a specific case to treat a specific witness or other person that's approaching the court in a certain way. I don't see what would prevent that.
I don't think anything would prevent them, but in practice,
Yeah.
it would, if somebody came up with some creative solution, which is not foreshadowed or in any way hinted at as being permissible, and to say this general language here would allow it, some judges are cautious, and I just...
Can you reread that section? I don't have it yet. The section 17.2a, you said that.
Yes. You want me to read it again? And I will read it, but I just want to make one other point. It says a court hearing a case. All of this depends on the order being made when the court is hearing a case. I think those words maybe we should change to say at any stage during the life of a case, or the more forensic way of expressing that, but it should be from the matter comes before the court, not at trial. It shouldn't be not while the case is being heard. Yeah, but I'll read it again for you. It said, in the interest of the administration of justice, public safety, public order, or public morality, a court hearing a case in the exercise of its jurisdiction under this Act may direct that A, the identity of any person, including a witness in the case, shall be protected in the manner specified by the court. So it's very broad, the power is very broad. I'm just saying that because it's a new area, and there's no examples being provided of the types of orders that can be made, there's no guidance to the court as to what types of orders could exist. And there is legislation elsewhere, I'm pretty sure of it, around witness anonymity orders and other things of that nature that other jurisdictions have created to deal with this problem. And I wanted to see a 17 whatever, a 17...
No, I'm inclined to agree with the member.
17.5 that would say orders under 17.2a may include any of the following without limiting the generality of that power.
To be technical, I think you should consider SC and CPs to have a special order on this. You see, we're in an atmosphere, this thing of the anti-informer culture need to be very clearly rejected, and the witnesses can, for themselves, look at the law and say that they are being protected, and it's from the day from the very first statement they give to the police. That should be made clear that they can be anonymity. Because it's the biggest problem we have in dealing with most of our cases in the inner city, in where gangs are concerned. Nobody will speak to the police,
and
so you don't get to court at all.
Given how central this is, rather than say the court may direct that, you should also say shall consider whether the following. It should almost be mandatory that the court has to consider these issues rather than giving it a permissive power. Because
I'm inclined to, from a purely layman's point of view, I said getting first person affidavit is almost impossible in many of these cases. You can't compel them, but as sharply defined.
I just think it's in the nature of things that once you have a list there, the court is not going to expand its mind beyond the list. So I think that putting a list would be limited. I agree with the SG, yes.
Yeah.
My fear is that having no list means that there will be nothing done. No orders will be made. I don't know. But
as a compromise, could you look at it and to see whether what happens in other jurisdictions so that we can have the benefit of that information? Because it's possible that we might find some way in which our concerns, can be addressed.
Yeah. Sorry, Chairman,
we'll have a second look at this then.
So, right, we were going through our notes to refresh our minds as to where the proposal came from. And we recall our discussions with our colleagues from MOCA. Richard can just outline the basis for the discussion, why we made the proposal for the anonymity of the surveillance officers, which was the original proposal.
So I think what, if I can recall the discussions, that at the time of the court hearing, when they're trying to determine the credibility of the witness, they would have to provide their true names. So what MOCA and the agreement, what the discussions were, is that they would want them to use their names throughout the entire case, the entire court hearing, the entire case, etc. So they wouldn't have to give their true names at any point at all. So while 17.2 allows for the protection of the information, the identity, it doesn't allow for the pseudonyms then to be kept and utilized throughout the court case. That was my understanding of the discussions.
That's the problem with general words, because to my mind there's no doubt that it is wide enough to allow that. But then you have the practitioners out there incapable of saying that these general words cover that, or reluctant to do it because they're cautious and they want it to be spelled out for them.
And to add to that, the fact that both MOCA and the Ministry of National Security have expressed these concerns, and they're the ones who are really going to go and implement it, means that we must address it.
He has agreed that we have to find a way to tighten the band a bit. It's not judicial restriction.
So to be clear, the only issue is pseudonyms? Because I'm sure that can't be the only issue. You see, this is a problem I'm having. I'm not saying we're not going to do the work. We will. But
it's not
I can't believe, because in fact, again, I remember the discussion with MOCA. You see, there is so much we can legislate for. So sure, we can look to see what options there are. And more than likely, I suspect that our options are not going to drill down to say pseudonym.
Why can't we use the word term witness anonymity?
No, I'm just saying because I'm sure the only issue isn't a pseudonym. This is why
I'm looking at general anonymity for witnesses in these cases.
No, the issue is when it comes on to general witness anonymity, there has been proposed legislation, but it's not been progressing. And that is not a one section or a one provision. It was going to be a law. So we are now trying to see what we can facilitate, which was the intent of 17 to an extent. So for instance, if it is that 17.1 is too limiting, then we could look to see if we could expand it to ensure that it is not just applicable to the trial, but outside of that. 2A talks about identity. If we start going and drilling down into what we mean by identity, we could run into problems. That's my only issue. I hear MNS talking about pseudonyms, and I'm saying, I know that wasn't the only thing that came up. So we need to be careful about what sort of details we want. And I'm just also indicating that our research may again come up, and we may be making proposals that are a little more wide than what is being suggested right now.
Concluding, I think the basic policy is that we need to find a way in dealing with the gang cases to ensure the identity of the witnesses are not revealed very
not disclosed. I mean, for example, we mentioned the word hearing a case in the chapeau of 17.2. We need to expand that for sure. But also, for example, in witness statements, depositions, can those be anonymized, or whatever the verb is? Can the identity of the persons making those statements be protected? Because that's important, because those have to be shared with the defense. So if the name of the witness is there in the statement, I, Tom Brown of such and such, saw this, as to say, whatever, then that's a problem. So this ought to allow those, witness statements to be made by, in a way where the name is redacted or a pseudonym is used.
That's what I'm saying. Witness, the lack of identity have to come very early in the process, right?
Chair, if I'm understanding Member Golding correctly, we'll be talking about some very extensive and detailed provisions rather than this one simple section that is here.
You're correct there, but we need to put in, because I said to what extent you can without going to a new law, because the new law is going to take some time, and I think we really need this here. So I would leave it to you to advise me how to do this, but I think we need to have some level of anonymity once you start interrogating witnesses. Because it's just I mean, maybe from a layman's point of view, but I've had so many people in the inner city community who come to me and say, Dr. Chang, I see it, this is what happened. I graphically described it. People who cannot, the way they describe it, they cannot lying. And when this one said, but don't have to talk to a police officer, don't have to talk to anybody. And they sit there and they just not let us give any kind of information to anybody in our authority. They're finished.
I mean, I just would have liked to have seen a subsection 5 that says, for the purpose of protecting the identity of persons under 17.2, the court may use any of the following and any other mechanism that seems fair to it. But it would include things like the redaction of names from documents, the use of pseudonyms in documents, and at trial. That's a list of the kind of things that they want to be able to do.
I would describe the mechanism here. This is law. What I want is the principle established so those involved can decide whether to redact or to use pseudonyms or to put them on an audio-visual. What's the decision in it?
I only raise this because they have raised it. MOCA and the ministry have raised it, so obviously they consider it to be a problem. They don't think that the law is adequately addressing this issue.
I tend to agree with that. We need to do more in order to ensure that at the very outset the witness feel that there will not be, I mean, there's two sides to beside the name being given to the defense, the police they speak to, and this was brought by MOCA. It might be, in fact, indeed an investigation led by MOCA, and the individuals may feel comfortable talking to MOCA and might feel comfortable talking to the police. Right. The data is changed, and later on you can look at how they have to prove it, but all right. Are we settled here now on what we SG, CVD? Are we settled on the principle?
To do some research and for us to come up with something. Yes, Chairman, yes.
Take note of all the expression, what I was just said today, and you do the research and come back with something that will satisfy you. All right? You reject the fines here for those who $1 million is small fine in gang cases, Contravenes section 17.3 by publishing information in controversial direction of subsection 2. The fine is not exceeding $1 million or to imprisonment for a term not exceeding 12 months. And there was a proposal to increase the fine to $3 million or the penalty to 3 years. Why did we reject that? $1 million in any kind of, $1 million Jamaican is becoming smaller and smaller, diminishing value every day.
This is for publication of information, right?
Yeah.
In breach of a direction under 17.2. Well,
see, that's like releasing the witness name.
I mean, I wouldn't be opposed to increasing the monetary amount.
Yeah.
I mean, in the parish court,
I'd increase the amount. I suggest we increase the monetary amount, even if we don't increase the incarceration time. Right. For someone doing it, let's say it's someone who maybe have some loose arrangement that press, but 12 months is as bad for them as 3 years. But the fine should have some deterrence too. I think we should accept 3 million. Right. There are no more proposals on the specific sections. We go to new provisions, which I think we should do on the next sitting and get the reports from teams. Now let us set up firmly. You want to take a, you have a time for next week. Could we take a day and just do this thing? Members? Member Jackson, Golding, and Matic? Could we just set a day and just take a day and finish this thing? If they, we have a date, we have a space block for next week. I'm saying we don't finish, we could just set a day when we think we can give us 2 weeks to that. All right. Yeah. What date next week have there?
Next week, Wednesday at 2. That's the only day.
Wednesday at 2.
The legal reform and others would like 2 weeks to do the work we've asked them to do. Because they have to go look at what I want from them, is a suite of the types of orders that can be made to protect witness identity that we could just put as examples. Yeah, is it?
But we could meet next week and still go through and then.
Yeah, you're very.
And I certainly don't mind not doing it next week.
You prefer 3? You 3 days. I find Mr. Bailey, if she faster. We meet next to just conclude everything. What date?
And you will recall, Chair, that the Solicitor General had also offered to assist in terms of editing in relation to this. So I think the time we would really find that useful, 3 weeks.
If it's 3 weeks, you're looking at when?
Second Wednesday.
Second.
First Wednesday.
Well, what I suggest you block two blocks since nobody is there yet. Block 2 dates, the second and.
They on Wednesdays blocked out already on October.
Second and one.
They have all the Wednesdays blocked out for PAAC so far.
But what days would have 3 weeks from now?
Well, it's if we're not going to use the Wednesday.
No, you have the Wednesday for it, you say?
No.
The space is there for Wednesday?
Unless it's in the afternoon.
Wednesday afternoon? No, like
I'll
this
have to
evening?
double check, sir. Can I double check on
So block 2 afternoons then that week?
in October?
Yes.
Two
We must finish in October, first week in October. With the 2 Wednesdays or the 2 Thursdays, which one?
I'll have to confirm with the committee on that.
All right, please. We're going to give you the 3 weeks, Mr. Bailey, SG. Here, SG. I know you have a lot of things on your plate, so we'll give it 3 weeks. Mr. Bailey? You need 3 weeks. SG has a whole menu of activities she has to finish from here. I think I occupied most of her 3 weeks. You like this? Two days, and I expect we should not need beyond 2 days to complete this now. Once you bring the additional recommendations, we make a decision and maybe have a short sit in the set date. We're getting some. I mean, sir, I know you have a heavy load this grant, and a lot of it relates to us. I got a reminder from Mr. Sykes today of our commitments to FATF of which we are not in tune. Not just but he gave me the full list, which will come by you. There's 6 or 7 items. Sure, sorry. Six items, I think it was. We'll have to seek a lobby from Member Golding at the next big. You can lead a campaign, and I give you support to ensure that this is not this campaign. It's a bilateral campaign to ensure we increase the establishment for both the CPC and the SG department and pay them better, so we can keep a bigger staff. That's a bilateral, as a bipartisan campaign. All right. Okay, Mr. Bailey.
No Wednesdays free in October.
No morning, no evening.
No, they block off for 2 separate meetings for the whole month.
What kind of meeting they have?
Data protection, joint selector.
But we need this as well as bad data protection.
Unless we're going to meet on Monday.
Can meet Monday's cabinet day.
Oh yes.
But the Thursdays are free.
Thursdays.
All right. The data protection bill, which is critical, has blocked off all of the Wednesdays. We didn't go beyond that week. To go into October now, they can take our data that we just give up. Give us one. Yeah, I'm looking for 2 days. But if we go 3 weeks, data protection, which is also under pressure, have blocked off all of. Yes. Although we are freeing up 1 day, not well blocked already. Unless we still come. Suppose we'd use next Wednesday to complete review of the report, right? And then we find a day in October when we will do the wrapping up. Okay? And we can discuss on Wednesday whether we take a day, a special day, it's 3 weeks, or just block somewhere in the Thursdays for us in October. But we keep our date next Wednesday.
In the mornings.
Yeah. What do we do a block next week Wednesday?
No, we have 2 o'clock.
Yeah, we stick with next week Wednesday 2 o'clock, where we'll complete the review of the report and then give Mr. Bailey 3 weeks to do the research. All right? So next week Wednesday at 2 o'clock, and then we set a date especially after that when we'll be wrapping up everything. All right? Thank you, members. We adjourn until next week, 2 o'clock. Hold on now. 18th. No, I shouldn't stop us coming down.
Welcome to It's a Woman's World.
It's a woman's world.
Part of the whole coaching.
I went through an identity crisis. Shaping the future.
It's better to mind a jacket more than disown your own.
If a man really wants to leave, nothing will hold him.
Thank you, Dr. Michael Abraham.
New house
really
who
nice.
this?
There's a long-distance relay that's still on.